Not rock.
Just ready to roll, I guess.
Okay. I will call this meeting of the North Dakota Ethics Commission to order. Excuse me, it is 9:02 a.m. Are there any agenda additions?
Lord, I just have an amendment to the agenda. It's minor, but I'd like to note it. On item number 3, approval of the minutes, we have listed the May 6th and 7th meeting. We have the May 27th meeting, and then we have the June 3rd meeting. The June 3rd, with Alicia just working temporarily after hours, the June 3rd meeting minutes are not complete. And that was my fault. I should have made the assumption that they would have been. So we'll strike those from the agenda. We'll do those at the July meeting.
All right. We assume then that there are no other agenda additions. So then we would look for approval of the minutes from the May 6th and 7th regular meeting and the special meeting May 27th. We'd entertain a motion to that.
I'll move that we approve all 3 meetings. Minutes.
Okay. Is there support?
Second.
I'll second.
Okay, we have a motion with support. Any further discussion or questions on this? Hearing none, those in favor of the motion, please say aye. Aye.
Aye.
Any opposed, same sign. Motion carries. At this time, we will go to the executive director's report.
All right, so Logan is going to be our IT. He added IT expert to his job description this morning, right?
Yes, so.
All right, so you can see our budget update. I did have a chance to review these briefly with Alicia. I probably won't do it sufficient justice like she does, but you can see if we jump down, you can see what our appropriation is, that a little over a million, 1,165,897, I'll round up 16 cents. If you go down to our expenditures, where we are to date, if you want to keep going down, we didn't have anything unusual in this last month. I do want to talk about, hold on. I do want to talk about briefly the fact that our salaries, with Alicia having a temporary role for the month of June, we will save a little bit there. If you go down to our projected expenditures for the month of June, you'll see that our operations administrator has nothing. There's just a line, but then we added a little bit into temporary salary and benefits. You will see that Alicia's position, we have put some funds into there to cover that, and then that also covers the commissioner pay. So we did account for, in our projections, we accounted for not having Alicia working full-time, but having her working approximately, we were thinking it would be approximately 15 hours a month. She is well over that, so this might be a little bit shy on that estimate for temp salaries and benefits. But we just kind of estimated. The other thing that I want to note is that we still have expenditures, even though June is almost over. We do have funds for advertising of administrative rules. We'll talk a little bit about that later on in item number 7. But we do have funds that we have set aside to still get that done this month, or be able to pay for that this month, even though we are on really approaching the end of the month. So if you want to jump down. So far our ending balance for the biennium is looking like it will be a roughly 6,777. Again, this is conservative, and we will have, in July, we will have a much better idea of what our ending balance for the biennium is. I would say we will make it with just a little bit to spare. So the other thing I wanted to run you guys through is our professional fees and services. how that is looking. So if you remember correctly, back to the 2023 session, which feels like a long time ago, we had a total appropriation for professional fees, including a one-time and then an ongoing appropriation. That total came to a little over 121,000. And if you look down, we have about 36,000 remaining, closer to 37. We are going to have significant costs in June. We did utilize a SAG in the month of June to wrap up some complaints. So that will go down. But I just wanted to let the commission know that was a good estimate that we made way back in 2023 about what those costs were going to be. So any questions about the budget? Hopefully I can answer them.
You did a good job of following the budget and having just a very small carryover.
So Ward, that will be a turn back. We won't carry that over to the next biennium.
Yep, I knew that. I
Sorry.
misspoke.
Okay. Hearing no other questions, comments, concerns, we will jump to, I believe it is our filing update. I've lost my memo here. So this is just a filing update for the commission. I did change and needed to get this. This is a new document that was added as of this morning. And it really is that I needed to figure out where Alicia had this saved, but we got it. So this is our filing update for the month of May. And you can see, I'll give you guys kind of the rough numbers and then we'll talk about this chart. But in May, the commission received the following filings. We had 4 complaints come in. We did not have any quasi-judicial forms come in. We did not have any conflict of interest forms come in. And we had 14 meeting notices that came in during the month of May. In May, the commission closed 1 complaint. I anticipate in June and July, we will be closing more complaints based on how we prioritized our workload right out of session. The commission currently has 64 pending complaints. So I want to, this is a chart that we used, what is up on the screen. This is a chart that we used during legislative session. And we updated this on a regular basis. This seemed to provide individuals with a really good overview of what has happened historically. You can see that it shows from 2019 to 2025. And it also then has the total complaints received, informally resolved, pending, and then resolved. So this is a chart that we updated regularly through legislative session, as I said. So I thought that providing this chart to the commission every month would probably provide more information and than what we were previously providing the commission. So we made that change this month. It happened to also be the month that Alicia went temporary. So we were able to get it done. We actually had it done as of the 28th based on Alicia's last day. So there may be a few days, the 29th and 30th, that we did not have included on this. Any questions on this chart and the filings for May?
The pending resolutions or complaints in 2022, are those the complaints that we dealt with last month?
No, I can't answer that question.
All right.
I'm guessing I'll need to.
All right, that's fine.
Okay.
Any other questions?
Hearing none, we can go to our policies and procedures update. So in light of the turnover in our, or the passing away of Dave, our chair, we reviewed the policy regarding the length of officer terms. This was initially approved in 2023, and we are looking at amending this policy. Basically, it more in-depth articulates the chair's responsibilities and the vice chair's responsibilities. It does not change the term of either the chair or the vice chair, and when those positions commence. The election has to happen before September 1st of the year in which somebody is to be elected, and then that term starts in September. The most important or most significant change is in D, and based upon our conversation with Ward yesterday during our pre-meeting, we did make an amendment to the amendment in section D. And so this is a newly uploaded document as of this morning, where it does, so it basically articulates what happens when the chair vacates for any reason. For instance, with the passing of Dave, Ward is now our acting chair. So what this does, however, is it allows the vice chair the option to assume the role of the chair. And then following that vacancy, the vice chair is to notify the executive director in writing of their decision of whether to accept or decline the role as the chair. So following that written notification, the commission then considered the issue at the next regular commission meeting. If they do accept and they move to the role of the chair, then the commission is to elect a vice chair. If the vice chair declines the role as chair, then the commission elects a chair for the remainder of the unexpired term. This is, so the unwritten policy of Robert's Rules of Order is that the vice chair automatically assumes the chair position. So this allows for a little bit more flexibility for the vice chair in the way that the policy is written. So I guess I'd like the commission to consider this. We did add a notification provision in there, so that way the remaining members of the commission have time to consider whether they would like to be chair or not, in the instance that the vice chair declines the role as chair instead of doing it right away. So that notice provision is included for that reason. So I guess I'd offer this to the commission and ask them to consider, and we can make any changes that the commission sees fit.
Questions or comments? Rebecca, are you still looking for the motion to approve the length of officer term policy then?
Because it's a change word from the current policy, in most respects, that it articulates a little bit more in depth the chair responsibilities and the vice chair responsibilities, and then it provides for a more detailed succession. Yes, we do need to do that.
Okay.
I move approval.
Second.
We have a motion with support. Is there any discussion? Hearing none, roll call, please.
Commissioner Sosby,
Yes.
Commissioner Goodman,
Yes.
Commissioner Lindquist,
Yes.
and Chair Kozer.
Yes. Motion carries. Okay, we move on to the HR update.
So our HR updates, as the commission knows, May 30th was technically Alicia's last day as a full-time employee with the commission. She has been helping us on a temp basis. I do want to share with the commission that having 2 employees with a help or somebody who is working at night has certainly put some additional strain on our time. And I think we are working well through the transition, but we certainly have missed having that operations administrator here. And but with that, we did put out a request for applications. We had 23 applicants apply for the position. We've narrowed that down. We did a first round of interviews via Teams. Commissioner Goodman is assisting us with that process. He has done that before when we hired our general counsel, so we tapped him to do that again. And we also then conducted in-person interviews yesterday. And so we will continue to move through that process, and hopefully in July we can have somebody soon to be or already in that position. But I also just wanted to let the commission know we are going to have, Alicia will be sticking around to help through the training period. And that will be happening after her normal 8 to 5 job that she has taken on. So no requested action by the commission, just an update.
Any comments or questions?
Yes. You yesterday, 3 of the 3 finalists, and all of them are very good. We haven't made a decision yet, but all very good candidates.
Mm-hmm. We had a great applicant pool in general.
Wonderful. Okay, any others? Comments? Hearing none, we'll move on to advisory opinion requests.
Hand it over to Logan.
Sure. So I'll start with advisory opinion request 2501. This is a request the commission received actually back in January from Senator Joshua Boucher. The request relates to whether it's permissible under campaign finance law to use campaign contributions for caregiving expenses and security expenses while somebody's running for office or while they're in office at the state level. So back in January, due to legislative session and there being actually legislation that dealt with campaign finance in general and the unpredictability that that includes, we worked with Senator Boucher, as the commission's aware, to extend the deadline for issuance of this opinion. We're currently agreed on a deadline of on or before June 30th. So that is why you have a draft today for your consideration on this opinion. I will bring it up and run through it. That's probably the easiest way to do it. The first page really runs through the questions. Again, whether caregiving and security expenses are permissible. Here's the factual background about the request. The facts are a candidate for office / a public official plans to use campaign funds for those expenses, caregiving and security expenses. Senator Boucher did provide 11 advisory opinions from the Federal Election Commission. So the Federal Election Commission considers this issue pretty regularly when reviewing federal law. So that was helpful, but we do have to analyze North Dakota law, so we get into that. Again, just the background, the commission, what ethical violations are, how this would factor in as an ethical violation if somebody were to violate that campaign finance law. A little bit of background on commission advisory opinions and how we interpret statutes, and then getting into the crux of the campaign finance law. So the statute at issue is 16.1-08.1 4.1, which states a candidate may not use any contribution received. And then we're really focusing in on here to give a personal benefit to the candidate or another person. So personal benefit contribution, that's all defined in Century Code. Let me know if I'm going too fast or jump in with questions if you have any. Personal benefit also defined in Century Code, which is further broken down into a definition of you can't use it for something that's not a political purpose. So then you have to jump to the definition of political purpose, which is then included on your screen. I will not read that just to save time. So then we wanted to summarize what the other jurisdictions do because we do believe they're helpful, but as you read in the advisory opinion, they're not binding on either the commission or the courts. So we wanted to make that clear. But if you go through what the FEC has done, and as you'll see other states have done, it's helpful when we look to North Dakota law because it's very similar. So similarly at the federal level, there's the Federal Election Campaign Act, and then the FEC has its own regulations too that limit when federal candidates can use campaign funds. So the way the federal level defines it is personal use. I think we use personal benefit. Again, very similar. But then what the FEC has done is it's developed this irrespective test for the use of these funds when you're a candidate or a public official, whether the expense would have existed irrespective of you running or holding office. So if they further break it down, let's see. If the candidate can reasonably show that the expense at issue resulted from campaign or office holder activities, the FEC does not consider the use to be personal use. So in 2018, the FEC analyzed childcare expenses. The FEC said it's okay to use campaign funds for certain childcare expenses if they do not exist irrespective of the candidate's campaign for federal office. They need to be a direct result of campaign activity or holding office. That's the big one for childcare expenses, but then the FEC has quite a few when it comes to security expenses. They've done this in a series over the years, starting with a security system, typical household security system, cameras, locks, that type of thing. And then they've also analyzed cybersecurity issues as well, and personal security personnel, people actually like bodyguards, essentially. So the FEC has analyzed that and said, again, the same thing when it comes, if it's reasonably related to your campaign or holding office. There is some distinction when it comes to structural security. If you're improving your property, the FEC asks that individual members of Congress or federal officials actually ask the FEC to analyze the issue because it's so fact specific. So that there is some, not very many, I think there's one or two about building a fence. A certain person had a question about, well, I've been faced with this threat, so I need to build a fence, and then ask the FEC to analyze whether that's permissible. So then we look to other states and what their ethics commissions do. Some states specifically allow this in statute. Minnesota is one of them, Montana's another. There's others as well, but we look to our neighboring states first. Other states use advisory opinions, so we pulled Texas as another constitutional ethics commission, what they do. Again, they use different terminology, but it's all the same analysis. Statutes are a little different, how they're the words they use, the terms they use, it's pretty much the same analysis from the FEC in all these states. Another one we pulled is,
I was just gonna say Oklahoma and Kansas.
Oklahoma, Kansas, and there's Alaska, I
And
believe,
then-
as
yeah.
well. And then the big one for security expenses when it comes to the state level is Arkansas. They have an advisory opinion analyzing that issue as well. Again, concluding you can use it as long as it's reasonably related. I'm paraphrasing, but it's the same. If it's reasonably related to a campaign or holding office, you can use these funds according to all these jurisdictions.
Can I make a clarifying point on that? So when they talk about that it's reasonably related, they talked about a threat, that the threat that a individual may be receiving is not related to another activity, but is in fact related to, or is reasonably related to them serving office or because of their campaign. So you can't have an independent threat,
Yes,
security
that's
threat,
not related to
because it's not related.
your personal. The other thing, too, when it comes to the FEC and security expenses, what they were given in the requests and what they considered was what's referred to as the general threat environment that these public officials face. The Sergeant at Arms of the House of Representatives in Congress collects data on how many threats these individuals receive and how they respond to it. And it was so reoccurring that they just came up with this term, the general threat environment that members of Congress face. And they used that to say, yes, this exists. Therefore, responding with reasonable security measures, the security system, locks, what have you, is permissible because they all face the same general threat environment. So when we look to North Dakota law, it's pretty similar to federal law and the other states that we look to. Again, North Dakota's constitution in Article 14 actually prohibits the use of campaign contributions for personal use. And then it requires the legislature to set the criminal and civil penalties. The legislature already did that prior to Article 14 being created. This constitution uses a different term, but they are very similar when you apply the principles of statutory construction. So we look to the statute, what the statute requires, again, whether it's a political purpose or related to duties as an office holder, to the formatting software.
So sometimes it's strange when we even move documents, it'll jump on us. So we'll fix it.
So we, in the analysis, we broke it down what the statutory framework requires, what the statute requires. Highlighted here so you can see. Yeah. It really says a personal benefit using campaign contributions. A personal benefit does not occur when they're used for two types of expenditures. One is for any activity undertaken in support of or in opposition to the election or nomination of a candidate to public office, and two, for a purpose related to a candidate's responsibilities as a public office holder. We look to the other jurisdictions, what they did, but how do you answer this question? Well, it's whether they exist irrespective of the campaign duties or duties of a public office. That can get confusing, so we broke it down into a simpler question that those other jurisdictions also use. If the candidate or the elected public official can reasonably show the expense resulted from campaign or office holder activities. So then we turn to the questions that Senator Boucher asked. One was about caregiver expenses. This analysis outlines a few separate scenarios that can happen. The first one is somebody already requires caregiver expenses outside of their duties, so that's not reasonably related. So in that instance, it's not permitted. The second is they don't require it. Running for office or becoming a public official required them to go out and get these caregiver expenses. So in that instance, yes, you can show that it's reasonably related to holding public office. So in that instance, it's permitted. And then the third one is what is kind of a hybrid scenario where you have a public official who has caregiver expenses, but running for office or becoming a public official requires additional expenses. So in that instance, the regular expenses already existed, but the additional ones are reasonably related to holding public office or running for it. So again, that's permissible under the statute. Any questions on caregiver expenses? Okay. Security expenses. So recent events here have kind of highlighted this issue in Minnesota, and what is termed, I guess, the general threat environment, whether that applies in North Dakota. And if you read the analysis, we can conclude that, yes, that does apply in Minnesota, or in North Dakota, excuse me, following the shootings that happened to state legislators and their spouses in Minnesota. North Dakota has had some occurrences. Legislative Council took down legislators' addresses on their website to improve their security measures, but also somebody was charged, not threatening state officials, but threatening an individual in the U.S. Attorney's Office in North Dakota, and referencing the Minnesota shootings and that threat allegedly. So there are occurrences in North Dakota that apply to at least government officials. So there is this threat environment that the commission can consider when doing this analysis. Again, we walked through what happened, but that there's clearly something going on where holding public office or running for public office comes with this increased risk to your personal safety. So that does create an expense, again, following what other states have done, whether you can show that's reasonably related to holding public office for those. And then we pull in the FEC and the Arkansas analysis to highlight that. But if you can show it's reasonably related, security system locks, the same type of security measures, yes, that's permissible. But then also recognizing that if there is a specific threat, somebody should probably request an advisory opinion so we can analyze that specific issue for them. And then in closing, we just wanted to make sure that people are aware of there's the other fair market value consideration under the statute. You need to make sure anything that's permissible, you're paying the fair market value. And there's also the issue of whether it could become a gift to if you're not paying fair market value. So we just wanted to point that out. But that's the conclusion there. It's permissible in some scenarios to both questions.
Any questions for Logan?
I do. Just in this situation, does the Ethics Commission ever make a recommendation to amend state law based on what you have discovered in a situation like this. So would the Ethics Commission, perhaps in collaboration with the Legislative Council, say, this statute probably should be fine-tuned, and here are recommendations. Do you ever do that? Or should the commission do that?
I was gonna say, so Murray, that is something that the commission has considered before. We did send a letter last legislative session or made legislative council aware of a particular instance, and we were going to send a letter, and I think we ended up doing it as a phone conversation instead. However, with that said, the commission will be issuing an annual report that will come out in, I believe, within 60 days of the end of the biennium, so sometime in August or September. Many ethics commissions within those annual reports make recommendations regarding statutes or things that the legislature should maybe take under consideration, given an advisory opinion or some other action independent of the ethics commissioner that the ethics commission has taken or made notice of, etc. It's a very common practice with ethics commissions across the country. So I would anticipate, or at least it's a portion that I have noted in our draft, penciled out draft at this point of what we would include in the annual report is to review or to revise that specifically based on the analysis that we've done here.
You have answered my question very well. Thank you.
Yes. But I definitely think there's an opportunity to do that in that annual report. And that's something, I think we've had a discussion with the commission prior to you coming on that that's something that the commission would like to do. Right? Am I remembering that correctly?
Well, it's in the legislation requiring the annual report.
Yeah, there we go.
Yeah, it says that.
It would be a very proactive thing to do.
It would.
Any other comments or questions? At some point, we would be looking to entertain a motion to approve this.
I move to approve.
Okay,
I'll
is there
second.
support? We have a motion to approve the draft language and issue advisory opinion 25-001 to the requester and for publication on the commission's website. Any more discussion? Hearing none, roll call, please.
Commissioner Goodman,
Aye.
Commissioner Saxby,
Aye.
Commissioner Lindquist,
Aye.
and Chair Kozer.
Aye, motion carries.
I have a question for Logan. And maybe all of you who are lawyers, how much actual time have you spent on this? Do you and I hate to ask you it maybe on this in the form of our meetings, but I'm like, because it's very, very well written. This request came in when back in January, I think. Do you have any idea how much time you've spent on this to get to this point where we actually took action on it?
It's hard to quantify, Cindy, because I've worked on it off and on, but I've probably spent maybe a little less than a week's worth of work time on it.
I think he's being conservative, Cindy.
Yeah. I do too, because I'm just like, whoa, this is, and it's, again, as your non-lawyer, I'm like, whoa, but it's very well written where I understood it. And I really appreciated the analysis of the other state's perspective. I was really impressed that you brought in the Minnesota situation because current in that. So it's like, yeah, this is right on. But thank you. Really good work.
Yeah, it is. Okay, let's look at advisory opinion 25-02.
Sure. So this is the advisory opinion the commission considered at the special meeting on June 3rd, I believe. There was some discussion during the meeting about the analysis and not including an analysis of the fair market consideration exclusion that's in Article 14 of the Constitution regarding lobbyist gifts. So after further discussion in the office and with Commissioner Saxby, we went back and amended the language a little bit. So we still have time to issue the final opinion. So we went back and made an amended version of it, taking into consideration the commission's discussion, analyzing that issue, and making an amended version of the opinion. So I'll pull it up and just briefly walk through it. So again, the questions haven't changed. The factual background, I did find a little bit of an update there. Again, I guess I should say this is the request from Senator Bromberger regarding an event that he's presenting at, or 2 events he's presenting at. But regarding the factual background, I went back and looked at this agenda, and he was on, we had the regular event where he was going to serve on a panel, but they also updated the agenda for the second event that he asked about, and he will be serving on a panel there as well. So the time that he'll be investing presenting is about 90 minutes. So I made that change that he'll be presenting there for 90 minutes. He'll be working at these events for about 90 minutes. Moving along. I believe everything else is the same in the factual background. So here in legal background, we went back and we just wanted to emphasize that we're going to analyze this fair market consideration exception or exclusion, whatever you want to call it, that's in the Constitution in the definition of a gift. That's upcoming. So here is where the biggest change appears. This paragraph that I cannot see that. This paragraph right here, this first full paragraph. So analyzing what the language means in Article 14 when it says something that's exchange for fair market consideration, well, what does that mean? There's not a definition of fair market consideration. So again, you pull the plain language when it comes to interpreting these things. Look to the definition of fair consideration. What that definition is, there isn't a definition per se for fair market consideration. So it's really taking what fair consideration is and adding that market determination in. So it's equal to the market value to the thing being exchanged. That's what we came down to with that, and how you analyze a non-gift, for lack of a better term. So then we went back to advisory opinion 2302, and that's the advisory opinion that said travel expenses are unquestionably gifts. We wanted to make sure that we are clarifying that in those situations where there is fair market consideration exchange, that isn't necessarily a gift. I'm going to keep scrolling to find it's in the analysis here. So under A, that changed, not substantially, but it changed. So what does fair market consideration mean in this context? Well, Senator Bromberger and the facts he presented, and according to the agenda, he'll be participating in panels. So he's not there to serve solely as attendee. Again, he'll be working 90 minutes during the events. He'll be providing his public speaking services at the events. He's providing a thing of value, his services, in exchange for something. And in this case, it's the travel and registration expenses. So given the commission's discussion at the last meeting, we revised that to say, yes, he's exchanging that, and that doesn't meet the definition of a gift in Article 14. So there is no lobbyist gift analysis that takes place, whether he's being lobbied there, because he's working, he's providing a service. But that doesn't mean, so then we go on to B. If he's offered something else at the event, that's not in exchange for him working the event, he could still be lobbied at some point by this entity if there's something beyond his travel expenses, the registration costs. So he needs to keep that in mind if he's there attending the event, that if at some point they offer him food, I don't know what else they offer at the event.
Sporting event.
A sporting event, some form of recreation,
Tickets.
something outside of being there at the event that he's there to work and attend, he should make sure he's doing that lobbying analysis if there's something else that is offered to him. And that analysis didn't change. That's the same analysis that he needs to review the event, the content of the event, the sponsors are providing him while he's attending the rest of the presentations throughout, I think, the 2 days that he's there. So the conclusion doesn't change. The analysis changes for the most part. The conclusion does change a little bit. Based on that fair market consideration analysis, but it's the same answer. You can still attend the event and present, essentially, and accept those costs, but don't accept anything else if you're lobbying in conjunction with what's offered to you. If there's anything additional. Any questions?
I don't have a question. I just have a comment that I had a concern at the last meeting that that a legislator receiving or being reimbursed for travel-related expenses to go and speak about his expertise or his experience should not be considered a gift, because in effect he was working for the time that he devoted to it. And I like the way that the advisory opinion has been, the proposed amendments to clarify that.
Any other comments or questions? Okay, once again, we're looking for a motion to approve this draft amended language and issue advisory opinion 25-02 to the requester and for publication on the commission's website.
So move.
Second.
Support? We have a motion with support. Any more discussion? Hearing none, roll call, please.
Commissioner Goodman,
Aye.
Commissioner Sogsby,
Aye.
Commissioner Lindquist,
Aye.
and Chair Kozer.
Aye. Motion carries. Okay, we move down to advisory opinion requests 25 as 04, 05, and 06. We'll take those as one.
So the commission received 3 more requests, as Commissioner Koser just described, the 3 numbers. The first one is a request for an advisory opinion from Representative Zach Ista related to another travel invitation he received. I believe Rebecca met with Commissioner Koser to go over that one, and we notified Representative Ista that we would be issuing an opinion. We're kind of working with him too to get it out to him where it'll be useful to him. So we're looking to consider that one at the July meeting once we have a draft ready. The following day, we got another request from the Red River Valley Sugar Beet Growers Association through their executive director. They're going to be hosting a sugar beet harvest and factory tour this fall. Again, we met and notified them we would be issuing an opinion as well. we have a little bit longer timeline for that one than the first one, but we will be working on getting a draft done for that one. And then we also received a request from Treasurer Beadle related to a travel event that he is planning. So we'll be working with him to get an opinion out to him, getting a draft done on that one as well. That one's, I think, not on as tight of a time frame, but we'll still work to get a draft done as soon as possible.
There are some similarities between Representative Ista and Treasurer Beadle's requests.
Yes.
They're similar in nature and have similar overlapping entities. So as we are writing Representative Ista's, we'll also be keeping in mind Treasurer Beadle's at the same time. So just to give the commission a heads up, those are very related requests. But there's no action requested by the commission on those, just a heads up that we received those and that we've notified the individuals that we are going to be issuing opinions.
Okay.
What happened to 03?
So 03 has been requested. We do not have the opinion ready. So you will have that one, I believe, in July. But that was related to another travel event that somebody is attending as a member of an association and would like guidance on that. But the commission already was, I think we notified the commission at the last meeting in May that we received it and that we will issue it within the 90 days. So that is why it wasn't included.
I think we might have a little longer than July.
We
As
might.
well. I can't remember off the top.
Okay,
We may.
let's move on then to discussion of proposed travel disclosure rules.
So as the commission is aware, during the May meeting, we had a significant or lengthy discussion about the proposed travel disclosure rules for public officials in the state. Since then, we did initiate the rulemaking process on that. The hearing for those proposed travel disclosure rules is currently scheduled for July 14th, which is 2 days before the commission's next meeting. It's set for 9:30 a.m. in the Sakakawea room here at the Capitol. When we first moved these rules into the rulemaking process, we did send out a press release in early May. To date, we've only received one comment regarding the rule. I thought that we would have received more. So what we are going to do, I just wanted to update the commission that early next week, we are going to be sending out more information to stakeholders to solicit responses and ensure that everybody is available or knows about the hearing and can make comment on that. So that is just a kind of an update. We don't have anything substantive on those proposed travel disclosure rules, just to let you know that we're going to be trying to get the word out there more since we have not heard very much back.
What was the nature of the first comment?
It was a comment, I believe, quote me if I'm wrong, from a public citizen who liked the idea. Gave it a thumbs up. I don't have the specifics in front of me, Murray, but that was the general gist.
Just wondering.
Okay. Any more comments or questions on that? If not,
Rebecca,
Go ahead.
just remind me, please, how does this get disseminated when about the hearing? Does it go and for the legislative body?
Do you mean, does it go to the legislators?
Yeah, do we target them specifically for notice or no, or just we do our general public?
We do so it goes out 2 ways, Cindy. So, I mean, we send out a press release, which is the first thing that we do. And then the second thing is that it is published in each of the papers, county papers. I'm going to get it wrong. Is it
Official
county?
county
The
paper.
official county paper of each of the counties in the state. So that is the official legal notice of the hearing, but we do try to get it out there. It was also posted on our Facebook page. And then we also have, what is it called? The thing across the top on
The
our,
public input tab.
yeah, but the banner on our website,
Yeah.
the rotator, that's the fancy word I can never think of. So it is on there so that individuals can just click and hit or submit comments that way. And then it takes them to a public input tab, and then they can fill it out and just hit submit, and we receive notification of that. So we've tried to make it as simple as possible for individuals to submit comments. They can also submit comments at the hearing on the 14th.
Okay, thank you.
Okay. Let's move to discussion of proposed complaint rules amendments.
Okay, so I would encourage, I think we need to pull up, oh, Logan's already got it, a copy of the complaint process, which is what we call our complaint rules. It's chapter 115.0201 of the North Dakota Administrative Code. So if you remember during our budget update, we talked about that the fact that we have additional funds in our current biennium's budget to publish rules. So after having that budget discussion with Alicia, we said, hey, Logan, can you get these ones done before the end of June so we can get them published, meaning that we can make the request to the Newspaper Association and get this done still in this biennium and be able to use those funds that are currently available. We only have 3 rounds, or I believe it's 3 rounds of rule-making funds for the next biennium, so it would be good to use that. So Logan then went to work and said, yes, I can do this. And so these are the updates to the complaint process based upon the statutory changes that were enacted in Senate Bill 2004. So I'm going to have him, we also made some process changes that, in the rules based on how we actually run business in the commission, and how we do things in practice versus what's on paper. And so we wanted to make sure that those align. So we did those at the same time. They're kind of small minor things, but they do, we did want to make sure that the public was on notice of those. So with that, I'm going to have Logan run through these.
Okay.
And we have it pulled up so that you can see it.
So we had to add a few definitions. I'll go through them when we get to the substantive piece. I want to note that anonymous complaint, that's not new. I just moved it so everything's in alphabetical order. It was below for some reason, so I just moved it up. But I'll come back to those. So when we go to the jurisdiction piece of the rules, the commission stated its jurisdiction, but it didn't include political committee and contributor, which are also included in the definition of a respondent above. So for consistency, just putting them there. In subsections 2 and 3, the commission states what it doesn't have jurisdiction over. When it comes to legal drafting, that's kind of surplusage. You don't really need it in the rule if you don't have the jurisdiction. So it's just my recommendation to remove that, to cut down on words. Essentially, when you don't have jurisdiction, you don't necessarily really need to state it. But I also don't know why it was originally included in the rules. So if there's a reason, please let me know and we can discuss it. And then in the new subsection 2 there at the bottom of that piece, a complaint must be filed within 3 years of the date of the allegations in the complaint. Alleged violations crossed out because that's going to become a term with a defined definition. So we changed it to allegations in the complaint. And then the second sentence is crossed out because it doesn't really apply anymore. Violations occurring prior to January 5th. Well, we're already 6 years past that, so we just revert to the 3 years. Don't need the additional language anymore. Submission of a complaint to their complaint will be denied. We just changed that to summarily dismissed to keep with consistent practices. So then there's in subsection 3, there's relevant information used throughout the complaint rules, that term's not defined, so we just revert it back to complaint. When you submit something, it's a complaint. So it's a defined term and not the relevant information term, which is in the Constitution, but again, not defined. So subsection 4, we're adding there, the commission may direct a complainant to refile a complaint using the commission's designated complaint form. This is just to help us on a logistical standpoint. Sometimes complainants will submit information, but it's not well organized. So there may be times where it's helpful for the commission to have them go back and actually use the complaint form that walks them through it and what we're looking for to help us process the complaint rather than what they submit. Not that that isn't a complaint, but it may be helpful to use the actual form that the commission's created in some instances. Again, just removing other references to things that aren't complaints, since this is the complaint rules. Information, just extra words here and there. So then we get into subsection 7. And this is the appeal from a summary dismissal of a complaint. So as the commission's aware, when somebody has their complaint summarily dismissed, they have what is currently called an opportunity to appeal a complaint. A summary dismissal of the complaint to the commission is really, for all intents and purposes, asking the commission to reconsider the summary dismissal, because the rules state the executive director does a summary dismissal, but in practice, the executive director comes to the commission and asks the commission to direct the executive director to summarily dismiss a complaint. So after discussions, we thought it was clearer and cleaner to actually just change that to the commission as the entity that does the summary dismissal of a complaint. It's a commission decision currently, just by asking the executive director to do that. So just clarifying it, go directly to the commission summarily dismisses a complaint, and then getting rid of the appeal piece. That doesn't mean that they can't ask the commission to reconsider. They'll just ask they'll refile the complaint instead of filing what we call an appeal, which really isn't an appeal. I don't know how else to put that. It's just asking the commission to look at the complaint again, but they can do that by refiling it. There's nothing that prevents them from doing it. And this aligns with the standard practice that we currently do anyway.
So can I make a comment here
You
about?
could probably explain it better than I
No, I think Logan did a fantastic job of explaining this. So I think that the previous executive director had a practice of summarily dismissing and then notifying the commission afterward. But when I started as executive director, asking the commission to do that because one, it was kind of I wanted to ensure that the commission was aware of the complaints, and it seemed like the authority of the commission not to fall on one person as the executive director, with possible review. And I think that it puts, to have the executive director dismissing these, it does potentially put the executive director in this position where a decision could be appealed and create a bit of a conflict within the commission that's just unnecessary. Yes, there is an appeal, and at sometimes the executive director is presenting, findings of fact, conclusions of law to the commission in a hearing context, which is different. But as far as this, I have just found that this is the better practice, instead of having the executive director as one person summarily dismissing something, having commission action to do that. And we started doing that practice. I believe it was right away when I started. I'm not sure how it was done necessarily before, but I do remember that when I met with, it would have been, I believe Paul was the chair at the time. He had this preference as well. And it was really because he wanted to keep the commission informed about what was getting dismissed. And then Logan developed the form, which is the initial review form and allows the commission to evaluate. So I do think that this will align better to the practice of the commission instead of something that is antiquated that we don't do necessarily anymore. We also got questions about this during legislative session that, well, can't the executive director just dismiss something? And the answer is yes, with a but, right? With a qualifier, meaning that it's not necessarily the best practice to do that. And so this is our suggestion to share with the commission. Other ethics commissions do have their executive director dismiss things, but I think generally it is the commission who does that. So this is a mixed, meaning there are ethics commissions that do it either way, but based on our practice that we have thus far, I would say this is how we should go. Although we're open to comments and perspectives of commissioners as well.
Are there any comments or questions?
Yes. One of the first complaints I had when I was chair was a guy called me at home, and I don't think this is a problem discussing it. Called me at home, and he wanted the ethics commission to get his guns back through the sheriff's office. And, completely out of left field. And it seems to me on something like that, a frivolous complaint or a complaint that's obviously out of our jurisdiction is something that the executive director should just be able to dismiss without sharing it with us.
Okay. So one of the things that we do, Ron, now is that if we were to get a call like that now, because we do get calls, maybe not related to gun rights, but regarding other things, which we'll talk about later on, local, kind of local issues or concerns that have come up at the local level, where somebody will say, I'd like to file a complaint. And then what we do is how we respond to them is we inform them or talk to them about what the commission's jurisdiction is. And then we ask them usually, do you want to proceed with filing a complaint? Logan has perfected how he says it, but
What we do is if they say, I'm filing a complaint from the get-go, we'll accept that as a complaint.
Yeah.
But if they say, well, I'm raising this issue against maybe a local official, we'll go, okay, we had standard language it's escaping me what the standard language is, but we have standard language where we'll go back to them and say, are you intending to file a complaint with the commission? Please know we don't have jurisdiction over XYZ. And you do, in most contexts, like maybe the phone call you got, Ron, that clears up the issue. But if somebody is going on our website and filling out the form and going through that process, for records retention and record keeping purposes, we like to open a case, even though we're going to close it at the next meeting, because they're going through the process of filing a complaint.
so I think that concern is somewhat alleviated with how we address phone calls or in person, where we can't fix it or where we can't prevent it. Those frivolous
Emails.
complaints is when we get a direct email saying, I am filing a complaint. Or somebody goes online and files the form before they read what our jurisdiction
Or
is.
they mail us something. That happens
Yes.
quite often too, where they'll mail us something, maybe a local issue or what have you, where we feel like we need to give it some treatment that's not just a random phone call or email, because they're formalizing it in some form.
So that's not necessarily something you would share with us.
No, we don't share those phone calls.
Yeah.
Mm-mm. No,
Okay,
we get questions on that. As we're going to talk about in item number 10, that has become a common issue, or we get calls about child support, denial of benefits, HR issues, and we do not put those into our complaint list. We try to alleviate that or direct them to a private attorney, direct them to a state's attorney, or direct them to the department that they need to go to. Unless they are saying, I am filing a complaint. But a lot of times people will call and say, I have this issue. What should I do? Should I file a complaint? Well, we don't tell somebody whether they should or shouldn't file a complaint, but we do at least here's information about the commission and what we do, and then allow them to reach their conclusion. So I think we prevent that from even going down the complaint process.
Okay. Any other comments or questions on this matter?
Yeah, Ward, Rebecca and Logan, do you document those types of inquiries? And how much, I'm assuming that might be a little time consuming also.
So Cindy, that's a really good question. I'm going to talk a little bit about that in item number 10 on the agenda.
Yeah.
Generally don't document every time somebody calls. There's two reasons. Well, there's really one primary reason for that is because a lot of times individuals may not share their name or their, I don't know how we would necessarily document it as other than citizen calling with X concern. At one point we did start tracking that, but it was very time consuming. And so I think we did it for maybe a month to see how much time it took, and it was time consuming.
Yeah.
So we really don't track that. However, we have started to see patterns and kind of consistent phone calls related to certain issues. Hence why I want to have a discussion on 10 about what we are going to be doing going forward in that regard.
Okay. Good. Well, and then back to the topic here at hand and the document we're looking at. I really appreciate the detail that you both pay attention to. And for me, this really does clarify our practices. And that, again, I guess we have to get over saying, we're new, but we're still kind of a new entity. and so making mistakes and or learning on the way as we kind of flesh all this stuff out and the processes. And I think for me, it makes it very transparent. That here's where we were, and now here we're cleaning all this up because we've learned lessons and we've been redundant somewhat or whatever in that. So I really appreciate the work effort put into this. Thank you.
Okay, at some point, we're looking for a motion to direct the commission staff to start the rulemaking process for the proposed amendments to the complaint rules.
So Ward, I still have a few more pages to go.
Okay. Go ahead.
Explain.
I'm sorry.
That's okay. So here on 7D, moving along here, this is the first change that takes in, that incorporates the legislative changes from this session. So the legislature in our budget bill in section 11, they made this change to the criminal referral process. The first change is that it's no longer mandatory, it's at the commission's discretion. So changing that shall to may. And then also when the referral entity that we refer it to doesn't take any action within 60 days, the commission will then pick back up or has the option to pick back up its review of the complaint. So adding that to our rules from the statutory change, and then again, getting rid of section 8 because that is not really the practice we do with summary dismiss complaints. It goes to the commission anyway, so getting rid of that language. So in this next section, this is also a change based on the legislation. So in section 12 of that bill, there's a new subsection that says the respondent may petition the commission at any time to dismiss the complaint in the manner prescribed by the commission. So what we're doing here in the document on screen is prescribing that manner in subsection 5, that they can file a motion to dismiss, basically alleging the same things we review for summary dismissal on one of those 3 grounds, and then explaining why it should be dismissed for one of those reasons, and they can do that at any time. So maybe there's something we missed that they feel they need to raise in that motion, but they have that opportunity to do so now. Moving along, this next section. So this is also from the legislative changes regarding informal resolution. This is section 10 of our budget bill, if you're looking at that, but allowing the commission to step in and settle complaints when informal resolution is not successful. So adding that language here that we will do so, but pursuant to settlement guidelines, which we'll discuss later in today's agenda. But that the commission is the one settling complaints at that stage and not between the complainant and the respondent. Then the next section, just adding that language in there, informally resolved or settled with the commission. This next section, this is based on the commission's practice when it comes to resolving complaints. What we set up, if you remember, we went through some forms of how we would handle that process. One was a stipulation that we worked through with the respondent, how we resolve complaints, what the hearing looks like. I'm getting a little ahead of myself here that I see. But that's really subsection 3, the investigation file, how we handle that. That's turned over to the respondent. Now, subsections 1 or 2 in this portion, this is based on a legislative change as well. Section 12 of our budget bill directs that upon completion of an investigation, the executive director shall prepare a report and recommendation to the commission to close the matter or issue an alleged violation. Commission may issue an alleged violation, require additional investigation, or close the matter. So this is kind of a Frankenstein's monster, per se, of 1360 into the complaint process. It does add an extra step. I'm not quite sure why the legislature asked to do that, but that was what they wanted to do, so they did. So what they're requiring now is an additional report to the commission. It's a preliminary report and recommendation, is what the term we came up for it. That's just going to be a shortened report asking the commission to do 2 things, either issue the alleged violation or close the complaint. So that's why we need the definition. I'm going to scroll back up here, of an alleged violation. That's why that is added. What is an alleged violation? The legislature did not define that term, so we did. It's a formal written allegation, so with the respondents on notice what the hearing is going to be about if one is issued. So the way it'll work is we issue that preliminary report. Once the alleged violation is issued, if that's the option that the commission takes, then the executive director will go back and prepare that final report and recommendation, which is the more lengthier report, including the investigation findings for the hearing. And then that, together with the investigation file, will go to the respondent and the commission. Moving along, this is where we take that process that we outlined before and actually put it in the rule. We have a hearing, that becomes the record. The commission's chair, the chair's designee, acts as the hearing officer during that hearing. Prescribes the time and the procedural matters, and administer oaths if anybody has a witness that they bring to the hearing. Then just making sure that we have in the rule that it's audio or video recorded or recorded by a court recorder. The commission may want to use that as an option, so we just included that. And then saying it can take place via reliable electronic means if necessary. That would be like we're doing today through Teams. And then adding the deliberation piece, that's outside, that's the presence of those individuals listed. And then that the commission issues an order at the end of the process. A copy is provided to the respondent. Again, just cleaning up language here and there, you'll see cases change to complaint. Then the one big addition that's new is the complaint management time standard. So this is a requirement based on the legislation. for complaints, that the commission shall adopt rules for the efficient and timely disposition of complaints from receipt to resolution. So what we did here is we borrowed the court's time management standards for civil cases and the timelines that they have there. So their goal is 75% within a year, 90% within 545 days, and then 100% within 2 years. So these are goals. They don't, if a goal isn't met, it doesn't mean the complaint's dismissed. But instead, you'll see on that last 3B there, when a complaint doesn't meet the time standards, the commission needs to discuss why at the next meeting in an executive session, since it's confidential. And then we put in here too, since this is new, the commission will probably need to look back on it. Not necessarily go through the rulemaking process, but consider every biennium at a meeting whether we need to enter the rulemaking process to update these time standards. So most of these revisions, the primary thing with these revisions is to include the legislative changes, and then secondary is to just clarify what our process is for that final hearing, and then just to clean up some of the language. If you have questions, I'll be happy to answer them.
Any questions or comments? Hearing none, are you now ready for a motion, Logan?
The commission is.
Okay. We would entertain a motion to direct commission staff to start the rulemaking process for the proposed amendments to the complaint rule.
So moved.
Their support?
I'll second.
We have a motion with support. Any more discussion? Hearing none, roll call, please.
Yep, sorry, Ward, I apologize. Commissioner
No
Goodman,
problem.
I,
Commissioner Sagsby,
Aye.
Commissioner Lindquist,
Aye.
and Chair Kozer.
Aye, motion carries. We're going to take a 10-minute break now, so we'll be back at 10:35.
So we're adjourned for 10 minutes, Ward?
Yes, we are for 10 minutes.
slept pretty well last night.
have coffee with Sean yesterday, and I meant to take my iPad and show her some of the pictures, and I get halfway over there and realize I didn't even bring my iPad, but it's much more fun to see him on the iPad than yeah, yeah, okay, yeah. Okay, well, you have a good day and we'll chat with you later. Okay, love you, yeah. Yes, on Monday. Monday we go to Minot. And on Friday, he has a doctor's appointment too. It's Friday. Yep, and on Tuesday, he sees his urologist in Watford City. But also. Yeah, right, she's getting in today. Yeah, so. I am. That's funny. And she won't do whatever. Dedicated, yeah. Like this is gonna be. Yeah. And I am talking about. Let's not plan on. Maybe each. And you could get together, it's not ready for meals. Okay. Yeah, right. Yeah. Do you hear the dryer from the kitchen?
Yeah.
I didn't know. I got a message from Dr. Small's office that they have the records and everything.
Just wait.
there.
Do we have everyone back at Bismarck?
Yes,
Yeah.
we're here.
I'm telling a story, but that can wait.
Oh, okay. Sorry about that. Is it a long story?
Oh, it's not too long. I'll just finish it quickly. Anyway, my dad passed away. None of his first family were included in getting anything from the estate. I don't know that he even had a will. He had remarried, and apparently his wife was going to get everything. And as my wife and I are leaving his house, my brother comes up to me and he has a rock. And he says, Ron, here's your part of the estate. He gave me the rock.
From the lawn.
You know,
From the
well, no,
lawn.
from the driveway. Well, from the lawn, yes, because they lived in Colorado. Can't much of a lawn. So anyway, sorry, Ward.
No problem. We'll call a meeting back to order and move to the discussion of process for investigating relevant information.
All right. So, am I good to go, Ward?
Yes, go ahead.
All right. So at the May meeting, the commission directed the commission staff to draft rules for instances or times when the commission, whether it is a commissioner or a staff member, we don't necessarily receive a complaint, but we receive information that relates to a potential ethical violation. So these aren't instances where somebody calls and says, I have this information, I want to file a complaint. These are instances that maybe the commission learned something or a staff member learned something. And in light of this request, what we looked at is how can we do this? And maybe we don't need to reinvent the wheel here. And so what I'd like the commission to discuss today, I'm not requesting any action because given the changes with the complaint rule based on statutory changes, some of House Bill 1360 was rolled into House Bill 2004. So we don't necessarily want to do this word for word. We're going to have to go through and pick portions of this, but essentially creating a process that is similar to what was presented in House Bill 1360, where it would be where the commission is receiving information, and then it has a process in place in an administrative rule as to how to handle this, meaning it would go to the commission would consider whether this raises to a potential violation. It would issue an alleged violation or could call it an alleged violation and move from there. So what I am asking before we proceed with this work, I really want the commission to discuss this as an option to what was directed to the commission staff at the last meeting about drafting this sort of rule. If this is something that the commission would consider, or if they want to go a different direction.
Okay, what's your thoughts, Commission?
I have a comment about that, because hypothetically, someone, a citizen could come up to me and say, I know that you're on the Ethics Commission, and I don't want to, in my situation, I can't file a complaint, but here's information that you should know. And blurts it out. Well, you can't unhear some things that are told to you, and you may have information that is of a potential ethical violation. And the second situation is that when the Ethics Commission staff is doing their investigation on a existing complaint, the investigation may reveal information that previously unknown suggests that there has been an independent ethical violation. And it appears to me that the existing law and our existing rules don't address that situation very well. And so I personally think this is a good idea because to further the spirit and letter of the Constitution, Article 14. My comments.
Okay, other thoughts?
Well, I'm chewing here, sorry about that. There's another instance where you might hear something not from a conversation, but even in the media, you might hear it. You know, this person, in your mind, violated some ethical rule, and that is reported in the news. The question there is, I've always told people when they have been commenting on one thing or another, I'd say, well, we have to receive a complaint. And what it sounds like this discussion is for us to be more proactive with complaints that we hear about and doing something about that. Is that where we're at?
I think that would be maybe a question for Commissioner Stogsby, but that's my understanding is that, you know, you hear something, you learn about something, and the current only available method that's laid out in statute and in rule is having a formal complaint or having a complaint. This provides an additional avenue for reviewing a potential violation, but not needing to have that formal complaint.
Yeah. For example, the statute and the rules say that an individual can file a complaint. Well, I'm an individual, but I'm also a commissioner.
Mm-hmm.
And it creates an inherent conflict. If I hear information or become aware of information, whether it's from a newspaper or a curbside comment, and I file a complaint or I notify the commission of this information, am I in effect the complainant? And if so, what's my status? Do I have to recuse myself? I mean, it just gets a little bit complicated, and I think we should address the process for dealing with that. That's what I'm thinking.
And I think that when we had that discussion in May, what came to mind is that we already had that process, or we proposed that process during the legislative session, which was House Bill 1360, which established the commission receives relevant information. It doesn't take away the complaint process, it supplements it, and it creates an alternative or a secondary path. But we've already done some of the groundwork. We will have to evaluate confidentiality, how that applies to it. There are some things that were built into the statute that we can remove. We'll have to change some of the language. But it basically moves where their information comes, and then the commission evaluates that and determines if it's going to issue an alleged violation, notifying the individual, and it has a secondary process. But it builds in due process and the concerns, and it reduces the complexities that Murray is referring to. So we don't have inherent conflicts of interest because it's reviewed by the whole commission and not just one commissioner.
So with that background, I would like the staff to proceed on this approach.
Cindy, I know you have some thoughts.
Yeah. Yeah, thank you, Ron. There's an aspect of this that I'm sorry, it comes back to our discussions on education. And then the other part for me is how much of this do we want put in writing into rules, into the processes and procedures and that. But my perspective in the 6 years I've been on the commission now, and particularly as we've looked at some of these cases, complaints that have come forward, education, and a lot of it is what we would think would be common sense, but people are not following common sense. And again, I'm speaking really personally about some of the stuff that's come before us and the public's right to know, and what do they know and how do they know it, and then bringing forward a formal complaint. And should this really be a formal complaint? You know, and so are we going to end up coming up with a list of what we, in our years of existing now and getting this stuff, I guess, formalized as the North Dakota Ethics Commission? So we're going to be starting a list of, oh, this could be an ethical violation, or, you know, and that. And, you know, I think we're really good at what we do. But sometimes I get a little bit scared because it's like, oh my gosh, there's just too much bureaucracy already. And there, to me, there's a really fine line on this topic and what we're talking about in our perspectives on that education piece, which we all should be part of and which we are. And yet we got stymied by the legislature in not giving us another FTE. And so we put the brunt of it on our two professional staff, you know, in relative to, again, for me, the stuff that I think is common sense, but really it's not common sense anymore. So, okay, fine. We're going to quantify it, qualify it, and put it into due processes, procedures, and rules and that. So, yeah, I'm torn, but I agree. Yeah, I remember how we got here. And unfortunately, Rebecca and Logan, this puts much more work on you again. We're going down this little path that could, you know, it could expand. And how do you keep it reined? How do you keep it reined in? You know, and that. So sorry, and I think I'm talking more philosophically, but not really. It's the application of our work.
I think you're not talking about a path, you're talking about a rabbit hole.
Much better words, yes.
To open this up, it could lead to a lot of complaints that we initiate ourselves. You know, I see stuff every day that I could complain about. You know, so.
Cindy, I think that I know I'm not a commissioner, and I want to maybe address, or I think in the same way that we have that informal resolution, which can be an educational tool in the complaint process that's been formalized in statute and in the now in our rule, right, that the commission now has the ability to settle something with a person. I'm wondering if that can't be built in, and I think maybe this could potentially, right? We have to consider, and I want you guys to consider the full ramifications, but that might be our first line of defense in this process, that the commission has Logan or I or somebody have a conversation or attempt to informally resolve something before it gets to the bureaucratic process that we put into place. And if we were to put that as a kind of cornerstone of these rules, we could use it as an educational tool early on. Maybe just give that some consideration or thought. But I get your concern.
And Cynthia, my concern is that if, however it happens, information comes to me, am I prohibited from pursuing that potential ethical complaint or ethical problem simply because I'm a commissioner? I mean, and I could as a person file a complaint, a formal complaint, but does that take me out of the process of being a commissioner on that particular issue? So I just think that it would be helpful to address how we would do something like that.
Yeah, no, and I agree, Murray. I understand what you're saying, and actually, you're reiterating your perspective on this topic. It's like, oh yeah. So because I think we as a body, as a group, have learned some things. It's like, oh well, maybe we want to go down that rabbit hole and bring it up ourselves because we don't think this is ethical behavior. But yeah.
But Cindy, if that process allowed for what I'm going to phrase as early intervention, meaning that if the commission learns about something, we can address it. And maybe that gets to your concern about education. That might be the wrong phrase, but.
Yeah. I know, I understand, and I appreciate you all listening to my perspective on this and that the deep holes we can go down in that. But I do agree that, we've kind of been discussing we've been discussing this in different ways for several months now. So let's figure out some ways as to how we're going to do it. So, yeah.
Any other thoughts?
Yes, I'm worried that if we start to do this, we may, not necessarily the people right now, but at some point in the future, we may end up as a more authoritarian than we want to be. Where we make a decision on something to investigate something and we find that we shouldn't have our nose in that. I don't know. That's just speculation, but
Yeah. Well, it could happen.
I think that's something that we should certainly consider.
Well, Rebecca, do you kind of have a sense of what you need for direction here now?
So I think what we could do is we can take the core components of 1360, potentially build in some anti-authoritarian safeguards. Don't quote me on that, but I understand the sentiment. And then also provide for some early intervention in the process or early education in the settlement aspect. And that may tie in well with the settlement guidelines, which we would be talking about next, I believe. And that's for complaints, but potentially linking the two later on. So I do think that we have direction. We'll proceed with amending or adopting, changing House Bill 1360 to the extent that we can. There are portions that we'll just have to drop altogether, but I do think we have a general consensus or a good direction.
Okay.
And you guys
Okay.
can ultimately reject what we write. So
Sounds good. Okay, discussion of settlement guidelines.
yep. So I'm gonna have Logan pull up the campaign legal centers document. It was pretty, what I sent to the commission was really thorough, but I really just wanted to focus on a few pages. This is their enforcement upgrade for ethics commissions. It's kind of a guide of things that you should consider if you're not already doing this. And I'm specifically going to start on page 18. And I don't want the commission to think that we have to do this the way that it's done or outlined here, but I just wanted to provide this more for a discussion point, that it demonstrates how two separate ethics commissions do these settlement guidelines. So in House Bill 2004, sorry, Senate Bill 2004, I keep saying House Bill, there was the ability that was changed. It was added during conference committee to have the commission settle matters. And so we have put that, taken what was discussed and done during legislative session, and we have done two things. One, we have created letters to let those individuals know, either as a complainant or a respondent, know that this has been passed and that we are going to evaluate those cases that are through informal resolution and determine whether they are a good candidate for a settlement. And that right now we are establishing settlement guidelines. So I believe late last week, letters went out. Logan and I walked through each of the complaints to determine whether it was appropriate for the parties in those complaints to receive these letters. And so as you can see in our attachments, attachments 17 and 18, you can see the form letters that went out, not specific ones, but it was a form letter that went out. But not all of them have gone out. That's right.
Not all of them have gone out because we're working when Alicia's available
Yes.
to get them out. So there's some that still need to go.
Yes, there is. Thank you for the
In case
correction.
anybody's
Yes.
listening that might receive one.
Yep. And so basically, if there is a matter that has moved through informal resolution, what we did is we reached out and we shared these letters with them to let them know, one, we are in the process of coming up with settlement guidelines and that we are evaluating whether their case is a good candidate. And also then to let complainants know that even though it wasn't informally resolved and it was moved on to the next stage, it now may settle with the commission basically stepping in their shoes and attempting to settle. So it was really providing notice to everybody in the process. So after that is done, we then also have been talking about what are those settlement guidelines going to look like for the commission? And where do we start? How do we start creating these? So the whole goal of having settlement guidelines is to set expectations and then also to expedite the process so that as staff, we know that we can look to those guidelines and we can use those guidelines to expeditiously settle or resolve a matter. But it also lets the public know what the expectation is, and that both the respondents and then the members of the public will know what the expectation is when there is a complaint that comes in, or the complainant for that matter. It also has the ability to hold the commission accountable to a fair and consistent standard. That way, if the commission follows the settlement guidelines, we know that it's going to be a fair application or a fair penalty that is assessed. This can also then help build public trust, and it demonstrates to the public that there are consequences that are attached to an ethical violation. So as we talk about how to do these settlement guidelines, there's two different approaches that have been taken. And what we are going to essentially, I wanted to just kind of give this is really an information at this point. We're going to take this information and then draft settlement guidelines. We haven't had time to do that yet, but I wanted to let the commission know kind of what are our bases and where we're going with that. So there's two different ways that this has been done by ethics commissions. In the report from the Campaign Legal Center, they use Wisconsin Ethics Commission and then the City of Los Angeles's Ethics Commission as examples of two of these methods. And one of them is creating a settlement schedule, which is what they've done in Wisconsin, and you can see on your screen, essentially outlining what the settlement amount is going to be. And this is typically a percentage of the total penalty that is assessed or can be assessed either through rule or through statute. And it usually is based on either a late payment or a late submission, which you'll see at the bottom, or the, how do I want to say this, the occurrence, how many times a violation has occurred, kind of a first offense, second offense, third offense type situation. And so what these are is these are general guidelines. In Wisconsin, they also allow for aggravating and mitigating factors to be considered. And so that is something that we definitely will want to have included in the commission settlement guidelines. Are there aggravating factors that maybe make these settlement guidelines non-applicable, or that we need to deviate up or deviate down depending if there are mitigating factors? And so creating a settlement schedule is one way that it can be done. If you see also, for instance, on the late payment for lobbyist fees, they also have a warning option. So that would be kind of our educational outreach that we're saying, hey, this is a mistake. This is your warning. So they do utilize that as well. Settlement guidelines are not mandatory. They are guidelines that the Wisconsin Ethics Commission follows. But generally, they also then track information to see how many of their cases settle within guideline ranges, kind of akin to federal sentencing, and how many of them settle outside of those guideline ranges. So that also provides the public with information about how successful they are within those guidelines. So the other way that it can be done for settlement guidelines is the example of Los Angeles City Ethics Commission. And so this is not necessarily where it outlines what the exact penalty is going to be, or what the guide should be for a first offense, second offense, or for the number of days that something is late. Instead, this outlines a process. And when in the process of their complaint process, or their investigation process, I think is what they call it, then when you draft the stipulation, present it, and what can be included in the stipulation. And so you'll see that they have this as set up as more of a process base, and then they generally have that what they are authorized to settle for is roughly 50% reduction in the maximum charged penalty. So they kind of set that standard, and then they also allow for mitigating and aggravating factors to be considered. The Los Angeles City Ethics Commission is significantly larger, so they have more of a mandatory component to it, where they need to justify why somebody deviates from this. That's what they ask of their investigators. So it's just slightly different than in Wisconsin, where it's just generally a guideline. So these are kind of two different approaches that the commission could take. More of a process settlement approach, or more of a guideline or a schedule settlement type approach. So what we would recommend and how we're going to start working on this is somewhat of, I would call, a hybrid. And we don't want to make it confusing, but because of the way that the North Dakota Ethics Commission's rules and the statutes that apply to the Ethics Commission how those are worded, that some instances there are penalties that are attached to it. For instance, lobbying violations have a penalty attached to it, versus other instances where you don't necessarily have a penalty attached, for instance, the conflict of interest rules. So there, having a settlement schedule would not be effective, where having a settlement process would be a better solution. So in this instance, how I would like to approach it is creating a bit of a hybrid and having those work together. So I also wanted to note that ethics commissions vary by whether they put this in a rule or if they put this in a policy. I don't have a recommendation for the commission right now as to whether it should be a rule or a policy, but what was that? It will be a policy. Okay, we can do that. That's the way you have it. Okay. So I guess it'll be a policy. I love when that works. That's a decision made then. If we do it as a policy, we do want to make sure that we provide input time from the stakeholders in the way that we otherwise would with an administrative rule, but obviously we're not going through that administrative rule process. Yeah. So just a consideration, but we are going to start drafting these. I just wanted to let the commission know what we have done to date on settlement guidelines and how we are going to move forward. Any input, thoughts, directions on what the commission would like us to do on this? I do envision it's going to be a bit of a hybrid between the settlement process and settlement schedule, ultimately when we reach what we're going to be doing.
Okay. Any other questions? Let's move on then to discussion of ethical concerns at the local level.
All right, we're ready, Ward?
Yep, go ahead.
So over the past, I would say 6 to 8 months, we have, Logan and I and Alicia have noticed I would call it a noticeable increase in what we call inquiries or informal complaints. And this is those instances actually that Ron kind of articulated earlier, where somebody calls the commission and discusses or shares information that is happening in a local jurisdiction, whether it is a county, a city, or perhaps a township. And many times these relate to a potential conflict of interest. Sometimes it relates to gifting. Sometimes it relates to local lobbying. But we have noticed a noticeable, I don't want to call it significant, but there has certainly been an increase in these instances. We used to get a call maybe once a month, maybe once every other month about these issues. And I would say it's become as regular as 1 to 2 times a week. We are being contacted either by somebody who is serving at the local level or a public citizen who is interested in what is happening at the local level. So with that kind of change, or with the given the increase, I wanted to let the commission know this is data. So Cindy, this gets back to your question earlier. Although this is going to take additional time for us, we plan on tracking this data starting on July 1st of 2025. And the reason that we're going to track that, that's the beginning of the biennium, and this will at least provide us data and then provide other entities data with whether this is an issue that needs to be addressed and how we could potentially address that in the future. So we will be tracking on what the issue is, potentially what the location is. What we will not track is the individual who is calling us. So we will not take down their personal information. We won't make a record of that. what we will do is simply have what the issue is and potentially the location if they share that. So from time to time, we may update the commission on this data and what we are seeing and, create something for the commission. But really, we've just noticed a significant, I don't want to say significant, noticeable increase in these inquiries. We do have standard language that we do tell people. We explain that this falls outside the commission's jurisdiction, most likely, that they can contact their local state's attorney, a trusted county or city commissioner, or contact a private attorney is usually the language. Did I get that right? That is generally our language. And that is all I have, but maybe if the commission has additional things they want us to note or track, but I just wanted to let you guys know that we'll begin tracking this data.
Could you give us an example of the type of complaint or phone call you get or whatever?
So, yeah, Logan, do you want to do one?
Sure. So, well, a pretty standard one we'll get, whether it's county, city, or township level, is somebody will say, there is this zoning hearing going on. Somebody has an interest in the outcome of the zoning hearing. There's some potential conflict scenario. We'll say, well, the commission is focused on state level authority, so the resources we can direct you to is the state's attorney, or in that instance, you may need to contact a private attorney. That's the extent of information that we can offer. I think it's become somewhat frustrating for us because they're looking for resources and we don't have good resources to direct them to. But that's all we can do in that scenario. And it's frustrating for them as well to hear that, but it's what it is.
Any other thoughts, comments?
I'm curious, is there, and I hate to say this because I'm a non-tech person, but is there an aspect of this where, I don't know, AI or whatever, one of those tech functions could help in the initial screening or something? Is that an IT question? I mean, I don't know, and I get leery of that aspect of it, but because we're talking about human beings calling in and they really like talking to people.
So Cindy, we already have a built-in
Prompt.
prompt on our line,
Yeah.
on the hotline. And so we've kind of already built that in.
Okay.
Want to explain that maybe a little bit more?
Yeah, so we used to get a lot of calls for Sanford because the numbers went different, so people would call to schedule appointments. So what Alicia did is she worked with IT to set up this prompt that says, "Thank you for calling the hotline." I can't remember exactly
I
what
don't
it all
remember
says.
either. We could
but-
call it.
It talks about filing a complaint and then stay on the line if you want to file a complaint. And that's decreased quite a bit of those calls. The other thing, and maybe this is a solution as well, but at some point IT was going to give us access to Microsoft's AI platform. I don't know if there's something with emails that we get where we can develop something that way. That might be a possibility to cut down on the email side of it. Alicia would know more, but she's not here, so
Yeah.
I can ask her.
She was monitoring when that was they were gonna roll the Microsoft AI, I think it's called, is it Copilot?
Microsoft Copilot.
So they were gonna roll that out to some state agencies in June and July, I think she said. And then she thought we'd be getting it sometime in the fall. But we can verify that with her, Cindy. But that's a potential with email specifically, yeah.
Yes.
Yeah, phone calls we're still going to have to take and process kind of the old-fashioned way. But AI can certainly help us to create a report.
Any other thoughts? Okay, Let's move on to the update on the process for appointment of commissioners.
Yes. So this is very short. On May 29th, I communicated with the governor, Senate Majority Leader, and Senate Minority Leader requesting that they convene and fill the vacancy left by the death of Chair Anderson, as well as the expiration of Acting Chair Kozer's term. The other thing that we did in the letter is request the reappointment of Commissioner Sockstein. I believe that he can confirm that he has now submitted an application, and so that process is underway. General Counsel for the governor did reach out just last week and asked the commission to notify the public. So we will begin later this week. We will put out a press release. We will solicit applicants to the best of our ability, the same way that we did before when Murray came on the commission, and I think we've done it 2 other times now. But we will move forward with that process. So just kind of giving the commission an update on what that looks like. Is there any questions, concerns, ideas about who we could be communicating with to get the word out there?
I responded to a State Bar Association notice, and that went out a number of times.
Yep.
And they have a mechanism to get it out to all lawyers.
Any other thoughts?
Just a question, Rebecca, remind me, I think I might have already asked you this previously, but have you been able to give a good briefing to either the governor or the governor's point person on these appointments? About the commission and our terms and all that?
Cindy, I've been able to give a brief briefing. I had a phone call with Al Dorman. Is he the chief of staff? Or is he the
Chief of Operations Officer.
Yeah, I can't remember his official title. But it is too. But I don't want to say
Chief
that. and then be
Operations
wrong.
Officer.
So I had a conversation with Al Dorman. I'd have to find the date. I think it was a day or 2 before I sent the letter, and talked about the terms. He is the COO. Yep. The terms, how we've done it before, how the commission doesn't have a stake in it, but we facilitate and help out as best we can, and that we generally answer questions if applicants do have questions, because we have the information. Try to get them information about the time commitment, how much time is required, and then how often the meetings are, where the meetings take place, kind of those sorts of things. I would say it was maybe a 15-minute conversation, Cindy, so perhaps not as in-depth as we would like, but that is certainly something that we can do, is provide more of a formal briefing by letter or by memo or something to their office. There are certain restrictions. Oh, sorry.
Yeah.
There are certain restrictions in the Constitution about who can be appointed, and that is included in the posting that goes out.
Yeah. Yeah. Well, okay. So outside, and part of why I've asked this question in preparing for today's meeting, and that is that I think we should make a formal request to meet with the governor. And I think it should be an in-person meeting with the commissioners. He's a new governor coming from the federal level, even though I know he's a North Dakota person in that, but just based on this past legislative session, that I think he needs to hear from us directly about who we are and what we do, and to solidify relationship. And maybe that it kind of like what you've done already, Rebecca, relative to your work with the Legislative Council, and then the other one is the Attorney General's office. But maybe we need to look at putting more responsibility on us, the commissioners, to help with that process. And making sure we have supportive relationships with these entities, particularly for me as we get ready for the next legislative session. We got 2 years to do this, but my perspective is that there was some confusion and misunderstanding during legislative session about who we are, what we're about, what we're trying to do. And so you're going to have to help us figure that out. But again, as a commissioner, I'm making that formal request and to in support of our staff and the work of the staff. And given we only got 2 staff, okay, so maybe we can pick up some of that.
Okay.
Any other thoughts on this matter? Hearing none, we'll move down to the election of vice chair.
Lord, this is Murray. Could I just back up to the prior one, number 10, for just a minute?
Sure.
I think collecting this data would be useful so that at the end of the collection period, that data could be provided to the Association of Counties and the city
League of Cities.
League of Cities and the Legislative Council, because they may want to introduce legislation about this, and this would provide them with data that might be helpful.
Good point. Okay, back. Go ahead.
Sorry, I just wanted to let Cindy know we'll make that request to the governor's office. And then we'll keep you posted on when and where, et cetera.
Okay.
Thank you. And maybe it can be coordinated with one of our next meetings since we've got them scheduled.
Yep.
Yeah, thank you.
Okay, now to the election of vice chair.
I make a motion for Murray Sagsveen to serve as the vice chair for the North Dakota Ethics Commission.
Okay, we have a motion.
Well, you know why she did it. She didn't want her name on there.
Now, just so you know, we talked about this before the meeting started. I am not desiring to be the chair. I've had some health issues and I'm trying to get out of stress and change my schedule a little bit. So I feel bad saying that I don't want to be the chair, but I'm being honest with you.
Well, for the purpose of discussion, I'll second Cindy's motion.
Okay. Now any more discussion?
Yep,
I'll
Logan's
make it.
gonna direct you guys.
Yeah, so since you updated the policy now for how this operates, or given your intentions, you'll have to send written notification to Rebecca.
He did.
You did that already,
Did that.
okay. So then we'll have to carry it over and table it until the next meeting.
Oh, okay. So the whole matter will table till next meeting?
Yes, because we'll have to
Okay.
fill the chair,
So we'll be filling
Okay.
the chair, not the vice
not the
chair.
vice chair.
Okay.
Since that role is currently taken by you.
Logan, what do we need to do with the motion that's on the floor?
Either deny it or table it.
Well,
One or the other.
Or Cindy can withdraw it too, right?
Okay, yeah, I will withdraw it.
okay.
Yes.
Okay. Well, sorry to complicate matters for everybody, but I appreciate your cooperation and understanding.
Well, and let's just reaffirm too, though, Ward. I know your term is up here in August,
Right,
September, whatever. But again, you serve until you're replaced, right?
right. I understand
Yeah.
that.
Okay, so then at our July meeting, then we'll discuss or have action on officers for the commission.
Okay.
Thank you.
Okay, at this particular point in time, the next item on the agenda are complaint numbers 22-003 through 22-010, 23-14, 24-17, 24-18, 24-19, 24-21, 24-22, 24-23, 25-41, 25-42, 25-73, and 25-74. This item must be discussed in an executive session. The legal authority for closing this portion of the meeting is North Dakota Century Code 54-66-12, subset 1, North Dakota Century Code 54-66-12-3, and North Dakota Century Code 44-04-19.2-1. The topic or purpose of this executive session is discussion on complaint numbers 22-003 through 22-010, 23-014, 24-017, 24-018, 24-019, 24-021, 24-22, 24-23, 25-041, 25-042, 25-073, and 25-074. Information regarding the content and parties to a complaint to the Ethics Commission is confidential. As the complaint must be discussed in executive session, no motion is needed to enter executive session. The executive session will be recorded, and all members of the governing body are reminded to limit their discussion during executive session to the announced topic. Any collective decision, collective commitment, or other final action by the governing body must occur after it reconvenes in an open meeting. The prohibition on taking final action during the executive session does not apply to providing guidance or instructions to our attorney. We will now ask the members of the public who are attending the meeting to leave the meeting. We anticipate adjourning the executive session and reconvening the open portion of the meeting at approximately, what time should we say?
Logan is saying 12:30.
12:30. The minutes will show that the executive session began at 11:29 a.m. and was attended by Commissioners Sagsveen, Commissioner Goodman, Commissioner Lindquist, Commissioner Kozer, Executive Director Rebecca Binstock, and General Counsel Logan Carpenter. So at this point, we need to leave this meeting and go to our executive session.
Board, one
Yes.
comment. Special Assistant Attorney General Pat Munson is going to be joining us for discussion of complaints 24, the ones that she's assigned to, that she has been assigned to.
Okay, so we'll add her to the minutes. Okay,
Yep,
now
and then-
now we can.
Can we,
Now we can
and then
move.
Ward, is it possible for us to take a 10-minute break before we go into executive session?
Yes, it is.
Okay.
So we'll start the executive session at 11:40. Okay.
Thank you.